Good morning. See, there was a lot of confusions about whether appeal against the conviction would rise to appellate court, or if that appellate court dismissed the appeal, then what would arise against that, whether revision arise. These are all complicated questions being battled for years together to settle the law. But after 2009, a short amendment, when the intention of legislation was to give effect to the doctrine of victimology and facilitating the victims to work out their remedy if their grievances, their sufferings are not properly answered by the lower court. Here, this court, the Honorable Supreme Court, has again discussed that aspect. So I summarize the concept of the judgment as well as the procedure how to deal with appeal against acquittal, appeal against conviction, whether revision is maintainable or not. All these things are there. So this is most important judgment, AR 2022, Supreme Court 670, Joseph Stephen and other versus Santanasamy and another. Number 1, they say under 401 class 3 revision, the High Court has no power to convert finding of the acquittal into one of the conviction. That is first ratio. So if you prefer revision, the High Court cannot convert the conviction, convert the acquittal from then they can only remand back the case to the lower court. That was most. Then question arises, what is 372 proviso 378(4)? A revision against the order of acquittal by victim of a complaint cannot be entertained. Victim has power to prepare appeal as provided 372 or 378(4). Those are somewhat concurrently discussed about that. That I will come later. Then the High Court, if suppose feel that the revision may be converted as an appeal, then they have to pass judicial order. Why that was done? Here is the case. The lower court acquitted some of the accused for some accused for some of the offences and convicted for some of offences. Convicted accused preferred appeal that was allowed. The appeal preferred by the de facto complaint was dismissed. Thereafter, they seems to have filed appeal. In the appeal, High Court has converted the judgment of acquittal to conviction. That the Supreme Court said, no, you cannot do that under 401. You have to pass an order by judicial passing order to converting the revision as an appeal. So therefore, this is most important. You go through the entirety of judgment. First, prima facie, you must understand that appeal against conviction normally by the accused. Appeal against the acquittal, state can file it. If the state is not filing, victim can file it. If the complaint is upon a private complaint, you can file appeal. So you can 372 is meant for victim, 374 class 8 meant for class 4, 370 class meant for complaint initiated by the private person. This is the way. Anyhow, even if conviction by the lower court is set aside by the sessions court and passes acquittal, against that you can file 372. Or if the conviction, if the trial court itself acquits the, after full-fledged trial, you can file 372. Or else 378 class 4. This is the concept. You go through this. So many judgments were discussed. Those who are academically interested, equip you with all these particulars. Best wishes.